This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we speak about the duty to defend, which is broad, very broad, but not unlimited, and why exclusions defeat a claim for defense and indemnity, and why a genuine dispute dispels any claim of the tort of bad faith. In Diversified Restaurant Group, LLC, et al. Versus Houston Casualty Company, et al., the United States District Court for the Northern District of California on July 31, 2025, dealt with the claim of Diversified Restaurant Group and Golden Gate Bell LLC, who sued Houston Casualty Company, Pennsylvania Manufacturers Indemnity Company, and Manufacturers Alliance Insurance Company around the denial of insurance coverage for a lawsuit filed by a former employee who alleged sexual harassment and assault by a supervisor. DRG and GGB had insurance policies with PMIC and MAIC, which included general liability, workers' compensation, and employers' liability coverage, but both PMIC and MAIC denied coverage for the underlying lawsuit, citing various exclusions in their policies. The PMIC policy, for example, included employment-related practices, ERP, and employment liability, EL, exclusions, while the MAIC policy had a C.7 exclusion. These exclusions were used to justify the denial of coverage for the claims made in the underlying lawsuit. The former employee's lawsuit included claims of negligence, workplace sexual harassment, discrimination, and other related issues. The document detailed the specific allegations and the legal arguments surrounding the applicability of the insurance policy exclusions. The court emphasized that the duty to defend is broader than the duty to indemnify, but is measured by the nature and kinds of risk coverage by the policy. The court concluded that the insurers had no duty to defend the insureds in the underlying lawsuit due to the applicability of the exclusions. The insurer's duty to defend is not extinguished, however, until the insurer negates all facts suggesting potential coverage. Thus, an insurer may be excused from a duty to defend only when the third-party complaint can by no conceivable theory raise a single issue which could bring it within the policy coverage. However, the duty to defend is not unlimited. It is measured by the nature and kinds of risks covered by the policy. Under California law, which the district court was required to apply, interpretation of an insurance policy is a question of law and follows the general rules of contract interpretation. Therefore, the mutual intention of the parties at the time the contract is formed governs interpretation, and if the policy language is clear and explicit, it governs. The clear and explicit meaning of these provisions, interpreted in their ordinary and popular sense, unless used by the parties in a technical sense, or a special meaning is given to them by usage, controls judicial interpretation. In determining whether a claim creates the potential for coverage under an insurance policy, the court is guided by the principle that interpretation of an insurance policy is a question of law and the mutual intention of the parties at the time the contract is formed governs interpretation. Although the insureds attempted to impose a new carve-out to the arising out of phrase in the ERP exclusion, arguing that only claims between an employee and an employer, as opposed to harassment between two co-employees, are employment-related, the insureds fail to cite any case that imposes such an exception. Instead, courts have repeatedly construed arising out of broadly even when it is present in an exclusion. Because all alleged conduct in the underlying action against Moreno falls under the ERP exclusion coverage, the insureds have failed to establish any potential coverage under the PMIC agreement and thus have failed to state a claim for breach of contract with PMIC. The court need not address the insurer's argument contesting whether the claims of the underlying action are occurrences within the scope of coverage under coverage A. Whether or not they are occurrences, they would still be precluded by the ERP exclusion. A bad faith claim, also asserted by the plaintiffs, is subject to dismissal if the insurer shows a genuine dispute as to coverage. Given that ERP exclusion and the EL exclusion of the PMIC agreement and the C7 exclusion of the MAIC agreement apply to exclude coverage to DRG and GGB, the insurer's denial to continue defense and indemnification under its policy was reasonable and legally justified. As such, the insureds cannot maintain a statutory bad faith claim against the insurers for their refusal to defend and indemnify. Accordingly, the claims for breach of implied contract and claim for breach of the implied covenant cannot proceed against the insurers. The court therefore granted the motion to dismiss filed by PMIC and MAIC, agreeing that the exclusions in the insurance policy precluded coverage for the claims made in the underlying lawsuit. In my opinion, the United States District Court, in an exceedingly long opinion, reached the decision called for by the clear and unambiguous exclusions in the policies issued by the three insurer defendants, resulting in the dismissal of the suit. The mere fact that a plaintiff sues for the tort of bad faith is not enough. Facts and evidence are required. Since the exclusions created a genuine dispute, allowing the insurers to refuse coverage, it also eliminated the cause of action for bad faith. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll also gain access to the more than 5,150 blog postings. You can also subscribe to these videos at rumble.com and youtube.com. And if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. Please tell your friends and colleagues about this blog and these videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publications. Thank you for your attention.